Legal Pond.
Welcome to today's episode. If this is your first time joining us here, kindly subscribe to the channel and share to your colleagues to also subscribe and have benefit of same. Today, I am going to walk you through how to answer law questions. How to answer questions. When you are given legal questions, how do you go about it? Let us get started. Welcome back. Today's focus is going to be on types of questions you can be given as a law student to answer, and then how you should tackle them. Now, before I go into that, you know very well that back in high school, we were taught something called letter writing. And with that, one thing that I remember you were taught was that when you are given a formal letter, there is a structure you are expected to follow. So if, for instance, you are writing a formal letter, you are expected to state your writer's address, followed by your dates, followed by recipient address, followed by salutation, then you go to the heading, then you come to the body, then you go to conclusion, and then subscription, then you sign and all that. That is the format for answering formal or writing formal letters. The same way, when you are given an informal letter to write, you are also expected to follow a particular structure, such that if you don't follow that structure, you may be deemed to have answered it wrongly. So maybe the content might be right, but the structure might be wrong. The same thing applies to the answering of law questions. There is a format for answering every type of law question. Basically, there are two broad types of law questions which you can be given. We have one, the normal essay questions, and then two, the problem type questions. Now, what is the essay question? So for essay questions, mostly what happens is that you will be given a statement, a legal statement, then you'll be asked to discuss, analyze, evaluate, examine. So they are mostly short sentences, or even sometimes they are just a portion of a judgment that has been taken out, and they expect you to be able to justify it, to be able to explain what it means. So such questions are normal essay questions. So for instance, a question like the coming into force of the Contract Act 1960, Act 25, has watered away the common law rules on consideration. Discuss. So a question like this, you are expected to use it or answer it using the essay approach. Then there is a second type of question that you can be given, which is called the problem type or the fact patterned questions. Now, these questions are such that they will give you a hypothetical fact which has legal problems in it, which has legal issues in it, and then you are expected to fish out those legal problems and then resolve those problems with the laws that you've learned. And that one too, there is a structure you need to follow. So first of all, let us look at the problem type questions, how they are answered. Afterwards, we will look at how to answer essay questions. Now, for problem type questions, there is an approach, there is a method called the IRAC. IRAC is the initials of a whole system. Now, IRAC is spelled E-I-R-A-C. A-I-R-A-C, IRAC. Now, what is the IRAC? What does it mean? What does each letter stand for? Let us look at them. Now, the A in the IRAC stands for area of law. The A in the IRAC stands for area of law. The I stands for the issues. The I stands for issues. Then the R stands for rules, or you can call them laws. Then the other A stands for applications. And then the C, which is the last letter, stands for conclusion and advice. So, what does it mean to say area of law? What does it mean to say issue? What does it mean to say rules? What does it mean to say application? And what does it mean to say conclusion? Now, the area of law, which is the first step in using the IRAC, I always say that the area of law is the topic or topics under which the question that has been given to you falls. So if the question given to you falls under consideration, then it means the area of law is consideration. If the question that has been given to you falls under offer and acceptance, then it means your area of law will be offer and acceptance. Sometimes there may be specific subtopics under the topic where your question falls. So for instance, your question falls under offer and acceptance, but then you can see that the question is specifically on communication of acceptance. What it means is that your areas of law can be offer and acceptance, specifically communication of acceptance. So area of law is basically the topic under which the question falls. Then we have issues. When we say issues, now, after reading the question that has been given to you, after reading the fact that has been given to you, you are expected to detect the problems, the legal problems in the fact. You are expected to detect the contentions between the parties in the fact. And those contentions, those things that they are not agreeing upon in the fact, are what you call issues. So one party is saying that, oh, what I did was an offer. The other party is saying, no, it wasn't an offer, it was an invitation to treat. So one issue is there, whether or not that particular thing is an offer or invitation to treat. It can be that in the case one party is saying A, the other party is saying B. So your issue is whether or not it is A or B. And then you can have multiple issues in one fact. But what I want you to understand is that when we say issue is basically the problems, the contention, the misunderstandings between the parties in the fact. And you are expected to raise them. How do you raise them? You will get to know when we start the practicals. Again, you move on to rules. Now, what are the rules? The R. Rules means the laws after detecting the issues, the problems. The question is, which laws can solve the problems? Which of the laws you've learnt in class can answer the issue, can resolve the issue? Which law is applicable to the issue? First of all, you discovered the area of law, you have raised the problem there, and now you are expected to tell us which of the laws under the topic that you have raised can answer the issue. So that is where you write those laws, the rules. The rules section is where you write those laws. Now, after writing your rules or your laws, you are expected to go ahead and apply the law to the fact that has been given to you. So it is at the application stage that you compare the laws you have written to the fact that has been given to you to see whether it answers your issue or not. So it is at the application stage that you do that work. So we say you are applying the laws to the facts. How is it done? We are going to look at it during the practical stage. The same way, after doing your applications, you do it separately for each issue. After doing your applications, you are now expected to conclude. So on each issue, you have to conclude answering the issue. So let's assume that your issue is whether or not Kofi is a boy. Now, after writing your laws and doing your application for that issue, you must conclude that Kofi is a boy or not. Then you pick the second issue, you go through the same process, rules, application, conclusion. Then after attacking all your issues raised, you now have to come and draw a bigger conclusion, and that is the C in the IRAC. So the C in the IRAC means two things. One, it means conclusion under each issue, and two, the broader conclusion. And it is at the stage where you are doing the broader conclusion, that's where you also advise the parties. So at the final conclusion, you now have to combine all your conclusions from the issues, put them together as one or two paragraphs, and then you advise the parties according to your conclusions. So let's assume the first issue is whether or not Kofi made an offer. Second issue, whether or not Ama's acceptance was valid. And the first issue, you concluded that yes, Kofi made an offer. And two, the second issue, your conclusion was that Ama made a valid acceptance. Therefore, your general conclusion should be that they have a valid contract. And therefore, the party who is at breach is liable to whether damages or whatever, depending on what the question wants you to advise them about. So let us pick a sample question and see how we write these things. So we are picking a typical problem question. We will read the question together and then we will go ahead to answer it. Let's get into it.
The legal pond.
Welcome back. So that is the question on your screen. This is a typical problem type question. Now, let us read the question together. It says that Kayla and Janelle are sisters. On 1st March 2025, Kayla meets her sister for a drink and tells her she is looking for a new sports car. Janelle replies that she wants to sell her red Kantanga on 94 as there is now a better model available and that she is happy to sell it to her sister on a business basis. Janelle says she wants 100,000 for it. That evening, Kayla sends an email to Janelle saying, I accept your offer to sell the car for 100,000 and will return the money in few days. On 3rd March 2025, Janelle sends Kayla an email that says, don't be stupid. I wouldn't sell the car for that. I want 125,000 cedis for it. To avoid any further misunderstanding, do not email me again unless you do want the car at this price. Kayla was so annoyed on reading the first sentence of Janelle's email that she deleted it without reading further and did not reply. 3 weeks later, Janelle rang Kayla and demanded 125,000 in order for the car to be delivered to Kayla. Advise Kayla. So this is a typical problem type question where you are giving facts to fish out the issues and then use the laws you know under them to resolve it. So we are going to use the IRAC just as I explained earlier. Now, so from the IRAC approach we discussed, you know that you will first have to state your area of law. And then as I said, they are the topics under which the question falls. So what you do is that you don't write topic, area of law, then you underline, then you list the topics. No, you put it in a sentence form, just as we have done over here. So from the facts that we've read, please focus on the structure. We are not so much into the substance of the work. We are focusing on the structure. So from the fact that we read, you notice that the topics under which the fact falls are these ones that I have listed here. So this is how we write it. The given set of facts fall under elements of a valid contract, specifically intention to create legal relations, offer, and acceptance. So you see, my areas of law are the topics that I believe this question falls under. And then this is how you put it in a simple way. That is how you state your area of law. This will be marked. The given set of fact falls under element of a valid contract. So this is the first topic, first area of law, element of a valid contract. But then it falls under specific elements. So I went ahead to say specifically, intention to create legal relations. I added offer and acceptance. These are the topics I believe it falls under. So those are my areas of law. Now, the next thing in the IRAC is to write my issues. So in writing the issues, I don't have to write topic, issue, and then list the issues. No, I need to create a link between the areas of law and the issues. So I went ahead to say the issues arising for determination are, then I add my issues. And it is always safe to write your issues, list them, and then write it starting with whether or not. It is always safe to do that. People have different ways of writing the issues, but I always go for this because it is the most popular and the most simple way to write your issues. So whether or not Kayla and Janelle intended to create legal relations for the sale of the red Katanka or 94, that is my first issue. Then the next issue is whether or not Janelle's intention to revoke her initial offer to sell the car for 100,000 and the subsequent demand for 125,000 was valid. So that is my second issue. This is how you state them. Now, afterwards, from the approach we learned, we said that after stating your issue, the next thing in the IRAC is the R, the rules. So what you do from here is that you pick the first issue and then you put it in a topic form, just as I have done here. Some people can reduce it into topic sentences. So whether there is intention to create legal relations, short form. But if you don't want problem, do it as I have done here. Write the whole issue, just pick it and write it in caps and underline. Then you start writing the laws under the topic, which you think will answer this issue. Now, your issue is whether or not Kayla and Janelle intended to create legal relations. So you would have to go ahead and write all the laws on the intention to create legal relations, which you think is relevant for the issue at hand. So all these places that I have copied here, I have highlighted here, are the rules that I believe are okay for stating the issues or for answering the issues, this particular issue. Now, one thing in writing the laws is that the laws comes with authorities. And then in writing your laws, if you want to use your authorities well in writing your laws, you do not have to start your writing with authority. So this one, for instance, you see, I stated the principle that I wanted to state here first before adding my authority. So I said it is a general law that parties to an agreement are free to determine the content and nature of their agreement. Accordingly, not all agreements are intended to give rise to legally binding contracts. The parties may indicate their intention to create legal relations or otherwise by expressly indicating same in a contractual document. I went ahead to say that this was noted in the case of Rose and Frank versus Crompton Brothers. So I didn't start by saying that according to Rose and Frank versus Crompton Brothers, the law is that. No, that's not how it is done. You talk about the principle first, then you add the authority in this manner. Now, one other thing that I want you to understand at this stage is that when answering problem questions, you should assume that you have a client before you that you are going to advise. So when you are giving authorities, you are not expected to brief the whole case. So for instance, Rose and Frank versus Crompton Brothers, then I go ahead to brief. Oh no, that's not how it is done, because the person you are advising is not interested in the facts of the case. He's interested in the advice. So because of time and the nature of questions of this type, we do not brief the cases here. We use our authority to support the principles. So yours is to make sure you state the principles well. Then you go ahead to discuss the other law. Now, one other thing you need to also know here is that after communicating each idea or explaining every principle, it is advisable to leave a paragraph or a line before you communicate another idea. And you realize that even when I was communicating the next idea, I used the same approach here. Principle first before authority. That is how it is done. Principle before authority. Principle before authority. When you look at this place, do the same thing. Principle before authority. When you come here, this side, you also notice that there is principle before authority. One thing that I want you to know is that now, in case you want to say something about the case, you have cited the case and then you want to say something about it. You just don't want to mention the case. As I said, you are not supposed to brief the whole case. You can say something small about the case in 2 or 3 lines because you don't have time on your side. So look at what happened here. I was stating this exception and I said, however, where a domestic agreement such as family agreements between relatives is made with business flavor, it shall be deemed as giving rise to intention to create legal relations. This was espoused in Semkin versus Peace. I could have ended here, but I felt like saying something small about the case. So I continued by saying, where the court held that because the parties made contributions for the raffle with intention to share the profit, they intended to create legal relations, even though they were relatives. So this is something small I said about the case. It is enough to give you the marks you want. You need not go ahead to brief the whole case. You won't even get the time. Assuming you are using 10 cases, how are you going to do it? So you've discussed your laws at the rule stage, just as we've done here. At the rule stage, you discuss your laws beautifully. You discuss your laws beautifully. Then the next thing is application. Application. Now, the application stage, as we discussed earlier, is the stage where you now have to compare the laws you have discussed above with the fact that has been given to you. This is not where you come and cite cases. This is not where you come and brief cases. Here, you are just comparing the laws to the facts. So, normally we start by saying, applying the above principles to the current case. When I say the current case, I mean the present fact that has been given to you. Some people may start by saying, in the instant case. Some people will say, in the present case. However you start it, it's okay. You don't have to write topic, application, then you start applying. It doesn't work like that. So I started by saying, applying the above principles to the case at hand, it appears that Kayla and Janelle are sisters. This presupposes that by reason of the laws discussed above, a contract between them is domestic in nature and should not give rise to legal relations. However, the given fact further indicate that Janelle wanted to sell the car to her sister on business basis. This gives the transaction a business flavor, and that even though domestic, it creates in legal relations. So you see, I have applied the law I stated here together with the exception here to the facts. Sorry? Yes, I have applied the law to the facts here. Now, after applying the laws, what is my conclusion on that issue? I told you the conclusion means 2 things. It means conclusion on each issue and conclusion and general conclusion. So here, the issue is that whether or not there was intention to create legal relations. Now, after applying my laws, I should be able to conclude to answer the issue. So you see my conclusion here for the first issue. Accordingly, Kayla and Janelle intended to create legal relations for the transfer of the car. Now, what is the issue? The issue is whether or not Kayla and Janelle intended to create legal relations for the sale of the car. What is the conclusion on the issue? Kayla and Janelle intended to create legal relations for the transfer of the car. So I have answered the issue. I have resolved the issue with the law. You pick the second issue. So we are done with the first issue. So you pick the second issue, then you come here, rewrite it, and underline it. Then you also go through the same process as you did for the first issue. So here you realize that I wrote all the laws here. I wrote all the laws here. Then after writing all the laws, I went ahead to apply it here. I went ahead to apply the laws to the facts. Then after applying the law, I concluded. And my conclusion should answer the issue. So here, my conclusion on the issue was that it follows therefore that Janelle's subsequent revocation of the offer and the demand for the 125,000 for the sale of the car is invalid since the revocation was done after the acceptance was communicated. Now, what was the issue? The issue was whether or not Janelle's intention to revoke her initial offer to sell the car and the subsequent demand for 125,000 was valid. So we are looking at whether the revocation was valid. And the answer is what? The answer is that Janelle's subsequent revocation of the offer and the demand for 125,000 is invalid. I have answered the issue. And I was able to answer it after discussing the laws and applying it. That is how it works. Now, afterwards, you come and do a general conclusion and advice. Now, at this stage, what you do is that you pick the conclusion from the first issue and the conclusion from the second issue, then you combine it. So here I said, from the above discussion, it has been established that Kayla and Janelle intended to create legal relations. Yes, that was my first conclusion. The second one is Janelle's subsequent revocation for the offer and the demand for the 125,000 is invalid. That was my second conclusion on my second issue. Now, after these conclusions, I can now advise the parties. So I went ahead to advise the parties here, saying that accordingly, Kayla is advised to make a payment of 100,000 for the car as agreed under the original contract. However, if Janelle fails to make delivery of the car after such payment, Kayla is advised to institute a legal action against Janelle for breach of contract. Now, you see, I am advising Kayla alone. What did the question say? Let's go and see. The question said, advise Kayla. So I have answered the question. So basically, that is how the IRAC is done. And afterwards, this is how your answer will look like. This is how your answer will look like. So I believe when you keep practicing, you would be okay with it. Keep practicing with more questions and you'll be fine. All right. So that is how you go about the problem type questions. If you have any question, you can send a WhatsApp message to the numbers on your screen and then ask your question, or you can put it at the comment section. As I said earlier, we are all learning, so you may put your concerns there. I may be there to assist you. Some other people may be there to assist you as well. All right, let's look at the next type of question, which is the essay type question. Let's get into it.
The legal pond.
All right, now with the essay type question, I told you that with those types of question, they would give you a statement and they require you to require you to make a discussion, analyze it, or justify the statement. They will give you a statement, a legal statement, and ask you to analyze it. So, what is the structure? It is a normal essay. So, from various high schools, when you're writing essay, you have to write introduction, your body, and your conclusion. But then, writing or answering a law essay question is a bit demanding, in the sense that your introduction must have certain characteristics, your body must have certain characteristics, and your conclusion must also have certain characteristics. So for instance, you are to answer this question. This is the question we have. Let me open the screen, zoom it out. Good. Yes, this is the question. Is the doctrine of consideration and its related doctrine of promissory estoppel still relevant in light of the Contract Act? Consideration. Is it still necessary even upon the coming into force of the Contract Act? That is what the question is about. How do you answer it? Now, you first have to do your introduction. Now, what goes into the introduction is that your introduction must capture three things. One, your understanding to the question. And then two, if there are any relevant definition you want to bring, you are allowed to bring it. And then three, your roadmap. Now, the roadmap is to tell the marker or the examiner how you are going to arrange your work. So look at the introduction that was crafted here. Says that the question at hand requires a thorough discussion and in-depth analysis of the various modifications made by Ghana's Contract Act and the extent to which these modifications affect the doctrine of consideration and its related doctrine of promissory estoppel. I have demonstrated my understanding to the question. Then I went ahead to give a roadmap because I wanted to reserve my definitions for the body. So I said, this essay shall begin with a discussion on the doctrine of consideration and its related equitable doctrine of promissory estoppel. Second, a discussion on the various modifications made by the Contract Act, rendering the doctrine of consideration irrelevant and providing a better protection as the final part will encompass a general conclusion. So I gave my introduction in this way, and you realize that it captures my understanding and then the roadmap, how I am going to arrange my work. Now, the next thing is the body. What you do is that your body must pick your roadmap and reduce them down into topics and write on them. So here I said I will start with the essay shall begin with a discussion on the doctrine of promissory estoppel, the doctrine of consideration and its related equitable doctrine of promissory estoppel. So look at my first question. I said the doctrine of consideration as at common law and promissory estoppel. So I picked the first direction I gave to the lecturer, and I'm now going to discuss it as a topic. Then I wrote all the laws on promissory, all the laws on consideration and promissory estoppel. So I wrote it all. After writing all, I went back to pick the second roadmap. What is the second thing I said in the roadmap? I said, second, I will make a discussion on the various modifications made by the Contract Act. So we'll look at my second heading. My second heading is that consideration and promissory estoppel in light of the Contract Act. Then I went ahead to make the modifications made by the Contract Act. Then I said I will conclude. Then the next thing is the conclusion. That is it. So you see, I discussed my second heading here. I discussed it all. up to this point, after which I concluded. So in your conclusion, it must answer the question that was given you. Now the question is that upon the coming into force of the Contract Act, does it still make consideration relevant? So your conclusion should answer the question. So listen to what I said in the conclusion. I said, in light of the foregoing discussions, it is humbly submitted that the doctrine of consideration has not been entirely watered down in light of the Contract Act by the import of the sections 8.1, 8.2, 9, and section 10 of the Contract Act. This is because some rules of common law on consideration, such as the rule on past consideration and the definitional regime of consideration, are still relevant and applicable in Ghana since the Act did not touch them. However, by virtue of Section 8.2, the related doctrine of estoppel, promissory estoppel, is no more relevant in light of the Contract Act. So I have answered the question itself in my conclusion. And that is how you go about your essay question. So the most important thing is one, your introduction, and then your conclusion. It must speak for you. Now, in writing the body, it is the same as doing the IRAC. You write the principle before the authority. So here, for instance, you see I wrote the principle here, and then I went to say that this was established in Rootlet versus Grant. Sometimes, if you like, you go ahead to state a bit of the fact if you can. So for instance, let me see whether I can get, yes. So for instance, here I wanted to state a bit of the facts of Twiddle versus Atkinson. So I stated the principle first, that it is undebated at common law that consideration must flow from the promisee. Consequently, the promisee cannot sue on a promise if the consideration for that promise was provided by a third party, as noted in Twiddle versus Atkinson. So you see, I stated the principle. I went ahead to mention the case. Now, I wanted to say something about the case. Look at how I did it. After stating the case, I went ahead to say that, as noted in Twiddle and Atkinson, where the father-in-law made blah, 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 3 or 4 lines, I am done. This is not where you are supposed to brief case. No. Say the portion of the case that is needed. That is all. You don't brief entire case in a question unless the question requires you to do that. So it is the same thing as doing the IRAC. Principle before case, principle before case, principle before case. So that is how, in simple terms, that is how to tackle law questions, being it an essay question or a problem type question. Now, you should also know that all these things I'm telling you, there is a material you can get for yourself. It is called the Legal Writer. You can see it on my right at the right top corner there. That is the book. It is called the Legal Writer. Check the book. It teaches you how to do the IRAC, how to answer law questions with examples, so with sample questions and answers. It goes ahead to teach you how to avoid plagiarism. It goes ahead to teach you how to draft legal documents like opinion letters and what have you. If you need a copy, contact the numbers on the screen and you're going to get yourself one. I think they deliver it to every part in Ghana, so you can contact them.
The Legal Pond.